and the people shall win, and people shall win, the people shall win
under the Prevention of Terrorism Act. As earlier stated, we urge the state to very quickly, Your Honor, desist from charging their political opponents under the Prevention of Terrorism Act. Because, Your Honor, this is inflaming the passions of the Kenyan people, who have now become increasingly aware of their political rights and even economic rights, because they demand justice, they demand economic justice. So we ask that when you retire to consider our earlier submission, you will find that these young people should not take this plea as having committed acts of terrorism. Again, Your Honor, proviso to Section 2 is very clear. Where you find that there was no intention on the part of the demonstrators to go and commit acts that went beyond demonstrations, then you find the proviso to add to Section 2 of the Prevention of the Terrorism Act applies in their case, and that they can also answer charges if indeed the prosecution has evidence. It can charge them with any other charges, but not under the Prevention of Terrorism Act. As earlier mentioned, and I sit on this note and allow my colleagues to continue, Kibe, I'll yield the floor to Council Kibe Mungai. Matter is not before you, Your Honor, but when you took 5 minutes break, we also took similar timing and consulted with an honorable member of parliament, member for Manyata in Embu, who is supposed to be brought before you again. I reiterate, this is not the time to inflame the passions of Kenyans. It's a time to reflect on the challenges facing, bedeviling our nation, which is at a crossroads. And they should not use the judiciary as a weapon to silence dissent. Because dissent, Your Honor, is constitutional. And we are saying any law under the Constitution which goes against the express provisions of Constitution 2010, and that is Article 2, Your Honor, of the Constitution. Any law which is not consistent with the provisions of the Constitution is deemed to be void to the extent of any such inconsistency. We thank you for your patience. The whole country is waiting to hear your rulings in this matter. And our friends on the prosecution side will remind you that there's a charge sheet ready and they are ready to take a plea. We remind them also that just recently, even together with the Chief Justice Emeritus, we appeared in the case of Rose Njeri. And your brother magistrate ruled that Rose was not to take a plea and she was set free. We reiterate objection to plea taking by these young men. I don't see any woman in their midst. They're all young men. And Council Kibe will take it up from there. And Your Honor, if some of us retreat, it is not because of disrespect to this court, it's because we are still dealing with the aftermath of what happened yesterday, and we need to be able to go out and issue necessary statements to try and tame the state of disrepair or despair in our country.
Yes, Your Honor, shall be very short. 3 quick points. The first one, we've read the charge sheet in this particular matter. In number 2, somebody were killed, the protesters, and other people were injured. That is the protesters. The damage, the so-called damage in number 2, is significantly of a very minor nature that occurs in the majority of demonstrations across this country. So this charge sheet, with regard to these young men, is a proof of the point that you are making. That if the Pandora's box is open to permit the state that anybody who engages in acts of state or in acts of dissent against the government and the leaders of the day, Your Honor, there would be no point where this is going to stop. This is proof that the threshold can easily be lowered to the levels of absurdity. By all chance, terrorism is an international crime. FBI, everybody else, MI6, Mossad, deal with such issues. We need to preserve the international image of the Republic of Kenya, not to be that this kind of young men in the good Republic of Kenya also called terrorists. Your Honor, we cannot get uncivilized. And if there is uncivilization outside, let it not come to the courts. Point number 2. Your Honor, by its nature, and I read you the provisions of the law in the CPC, for purposes of the trial of terrorist suspects, the law allows them to do two things. One, the rights under Article 50 to be significantly restricted lawfully under the law. And number 2, in the normal course of business, people charged with terrorist activities are not freed on bond. That is usually the norm. I'm here to be aware of somebody who was charged with terrorism and they were given bail. Ordinarily, I am aware. They are held until their trial is concluded. What's the point here? The point, Your Honor, is that before we set ourselves on this dangerous path of people exercising their rights of under the Constitution, under Articles 37 and 38 of the Constitutions, will be charged in an anti-terrorism court. This court is entitled to be satisfied that when I looked at those young men paraded before me, I saw people who, in my mind, and the mind of reasonable people, can be categorized as terrorists. Because, Your Honor, if you're not seeing terrorists before you, then it would be a circus, it would be an absurdity to try them as terrorists. Just to address the fears and paranoia of politics. That cannot be permitted. The last point, Your Honor, is this. Since we have seen how low it can get in order to call Kenyan people terrorists, and you take away their rights, Your Honor, what is the message? The message, Your Honor, is not these people. If you lock these people without bail and with less rights for exercising their political rights, the message effectively that this court and the judiciary as a whole is being required to take is to warn the millions of other Kenyans out there trying to exercise their fundamental rights that if you don't behave, we shall label you a terrorist and we shall try you as a terrorist. Your Honor, I beseech the Honorable Court to decline this gross abuse of power that is made apparent by the young men before you. If we start to say that our country can descend, can get into the pit, the question would be that the descent can be very steep. We shall go the way of Uganda, the kind of things that they do there. I urge this court to protect the Republic of Kenya from going along the route that Uganda has been unable to live since 1966, when they departed from their constitutional order. I urge the court to protect Kenya's constitutional order from the current perversion that has brought these people before the court. I am also obliged.
Your Honor, 1 minute. Permit me to refer you to section 89, subsection 5 of the CPC. It gives you the power to fail to admit a charge such as this one, where the magistrate is of the
89.
Section 89, subsection 5, where the magistrate is of the opinion that a complaint or a formal charge made or presented under this section does not disclose an offense, the magistrate shall make an order refusing to admit the complaint or formal charge and shall record this reason for the order. You know, that section gives you the footings or the grounding upon which you may decline to admit this provision. Finally, if you look at the charge sheet, Your Honor, the main count number 1, speaks about damage and assault. It is said that they damaged government offices, and it is equally said that they assaulted police officers. And if you go to the subsequent counts, that is count number 1 all the way to count number 7, then they have individualized the assault and the damage. For every allegation of assault, they have particularized that allegation. They have identified the person alleged to have been assaulted, and equally well for the damages. What that tells you, Your Honor, is that the individuals before you must be jailed for whatever reason. The DPP must nail them. If I don't nail them on count 1, I'll get them on count 2. If I don't get them on count 2, I'll get them on the subsequent counts. What that tells you, Your Honor, is that you need to look into the question of good faith in the manner in which these proceedings have been commenced. Number 2, the malice in it. The mule shall not escape the dragnet whatsoever reason. That is what the DPP is telling you. And that is why they have individualized and replicated the charges. On that point, Your Honor, I address you on the question of looking at the provisions of Section 4 of the ODPP Act, insofar as actuating and following up on the question of public interest is an issue. This is not such a charge that fits the principles to charge under Section 4 of the ODPP Act. Finally, the question of equal treatment and equal benefit of the law under Article 27. So that, Your Honor, if you are then to ask these individuals to plead these offenses and the subsequent one, where do you leave the question of the embarrassment and the ability of the accused persons to understand what exactly are they being charged with? I rest my case.
Just one point, Your Worship. I want to show you to Article 19, 3A and 3 of the Constitution. Article 19, 3A says, these rights are not privileges from the state. The right I'm talking about is the right under Article 37, Your Worship. So that nobody is giving us these privileges. These privileges are given to us as individuals by virtue of us being individuals or human beings. They are from God. Secondly, Your Honor, if you look at 3B of the same article, it says there are other rights under the international conventions and treaties and agreements signed by Kenya within the meaning of Article 2, 5, and 6 of the Constitution. Your Honor, if you look at the African Charter of the Human and People's Rights, look at Article 11, sorts of freedom of movement, freedom to associate, and other freedoms to protect. Those freedoms, Your Honor, Kenya has signed those international conventions. Kenya is not a banana republic. Kenya is a member of the Commonwealth, a member of the United Nations. That is why, Your Honor, our jurisprudence is quoted in other jurisdictions. So we urge the court to reject these charges in addition to the ground that I've been given, but I want to add Article 48. When I was coming here, I was stopped at the gate. And then I realized there were several armed personnel. Your Honor, if you look at the heading of the spirit of Article 48, access to justice, it also includes structures, because these are good structures. So if the access is inhibited, like what we encountered when we came in, then it becomes problematic because some of our mama mboga or our grandmothers cannot access these courts. Finally, if you look at the charge sheet, it has been promoted to PP, I think it is Principal Prosecution Counsel, Josiah Mwangi Kariuki, because it is written JM. JM in Kenya. So, we don't know We don't know whether this is the grandson of Josiah, but people can clarify who is JM. Yes, because this is written PPC JM. And Your Honor, this does not meet the legal requirement that the name and the rank of the prosecutor should be stated. Then look at the date of arrest, Your Honor. I'm looking at the first value of the charge sheet, a close interrogation of the charge sheet. Date of arrest is 2nd June 2025, which means these young men have been kept in custody for more than a month. For more than a month, Your Honor. And for that reason alone, you should acquit them today, because their constitutional rights under Article 49 have been violated, because they ought to have been brought to court within 24 hours. Your Honor, I want now you to juxtapose to the particulars in count 1. Look at the date of the offense. The date of the offense, Your Honor, we are just engaging in an intellectual interrogation of this charge on the face of it. You look at the particulars of the charge. The date of the offense is on 25th June, on 25th June of 2025. So, Your Honor, logically, if they were in custody on 2nd of June, it is not possible, logically and legitimately, for them to have committed an offense on 25th June. And for that reason, Your Honor, I submit with my learned colleagues as they have indicated that you reject this charge, because this is a sham. This is a sham. The final argument I want to advance, Your Honor, on this charge, as it is on the face value, look at the substance of count 1, which is similar to all the other counts 2, 3, 4, and 5. Same wording, same expression, same phraseology. But count 1 has been brought under the Terrorist Act. The subsequent counts have been brought under the police, assaulting a police officer under the Police Act. So they should tell us what logic they used to categorize one as terrorism and another as assault in different two legal regimes in one transaction. I rest my case, Your Honor.
Yes, please.
Your Honor, for the state, we need to submit in response as follows. As earlier submitted, the terrorism laws, Your Honor, are legal and valid laws of our country, of our land, recently enacted to fight terrorism. And I believe that although most defense counsel have not gone through the entire act, the same act has only 53 sections. And not only terrorists are charged under the Porter Act. In this case, Your Honor, we do not have any charge for membership of a terrorist group. And therefore, there is no illusion to the effect that the people before you are terrorists. All we are saying is that the offenses that were committed are not under Section 24 on membership, but the offenses that were committed are in respect to Section 4.1. They are people, Kenyans, but what they committed transcends legally what entails a terrorist act. The ODPP take cognizance of the fact that the right to picket and demonstrate is enshrined in the Constitution, and Kenyans should enjoy the same rights. But Kenyans must learn to know the boundaries of the same rights, which are limited in nature. We have so many Kenyans participating in demonstrations, but today, Your Honor, you only have 10 before you. What methodology was used to leave out all the rest who are at Matu? The acts they chose to consciously participate in. The damage of government offices, an innocent demonstrator would have kept off government offices. It is not the government office that they are contending against. What did Matu police station do to them? The innocent participants of Article 37 of the Constitution would not have attacked Matu police station. The government vehicle has no brain of its own. Why would someone attack a government vehicle? These are the acts we are saying they fall on all four on the definition of terrorist acts in Kenya. And the court, as forcibly persuaded by counsel, senior counsel for the defense, we equally submit together and join, with the defense in submitting that the court must stand out and protect the rights of the Constitution, such that in any demonstration, people demonstrate within the rights. If an action resorted to a terrorist act, the institutions of this government, of our country, Kenya, are able to zero in on the people who crossed the line. They in fact jumped from Article 37 all the way to Section 2A of Porter. They were supposed to be within Article 37 of the Constitution. Rights and privileges are submitted, are given by God, stored in the Constitution for protection, and the state is mandated to ensure that everybody, whether you're from which function, that these rights and privileges are protected. The government is interested to know who damaged that vehicle, who burned that police station. Who do you think will offer the services that you've just disrupted? Are you being fair in your right to demonstrate, to deny your Kenyan colleague the right to access a police station and report, or a government office to do a that transaction? That is why we are before the court. And the sentiments that we have, let those sentiments not affect the matters that we are supposed to apply our legal mind without any bias from wherever you function, whatever function we belong to. You've been asked by Degwanjiru that Section 895 is a section with the legal force enough to have these charges dismissed. There is no statement given today, Your Honor, further from the truth as that statement. Section 89.5 requires you to look as to whether the facts discloses any offense. Almost the whole of the day, we've been arguing about the facts, and these facts discloses acts, and these acts are defined by the law as terrorism acts. The only question that is pending is whether they are guilty of the acts and therefore guilty of commission of the terrorist act, and that removes the court from acting under section 895 of the CPC. As crafted, Your Honor, a section of the law called the joinder of counts is applicable here. What would happen if I go stealing in company of my friend and we are two? I do not have a weapon. It becomes a robbery with violence. Why should the DPP not charge these people with stealing? That is what they're asking us. And our answer to that question is that because the law tells us not to, the law describes that act as an act of terrorism. We are not the finders of verdict. The court, properly sitting, will say whether any of the 10 is proven beyond a reasonable doubt to have indeed participated and committed the same terrorist acts. In essence, what I'm saying is there is no malice. The charge sheet is signed pursuant to Article 157 of the Constitution without any directions. The ODPP, acting independently, has approved the charges, and under Article 245 of the Constitution, the office of the IG of Police, which exercises independent command in matters investigation and enforcement, equally investigated and found that these circumstances ought to be interrogated by the court through trial to determine indeed whether the participants mentioned herein committed terrorist acts. They do not need to be terrorists to commit terrorist acts. They just need to commit a terrorist act for them to be charged by the court. Yona Porter prosecutes both terrorists, sympathizers, associates, and even facilitators. Wherever they fall, that is matters of evidence. So we submit, Your Honor, that without wasting a lot of court's time, may the DPP be allowed, Your Honor. Now we've already decided to charge. May we be allowed, Your Honor, to plea. And we ask the court to file as per our submissions. I'll just leave a few minutes to my colleagues to finish.
Your Honor, with your kind permission, I will react to a few issues that are raised by Mr. Kibe as senior counsel, and let it not be seen as though I have been sent to target him because I'm responding to him only. He has raised a few issues with regards to bail and bond issues in terrorism cases. You know, the assumption that those that are charged under Porter cannot be granted bail or bond, it is not true. Your Honor, the Constitution under Article 49, 1G and H, provides that an arrested person has a right to be granted bond when presented and can only be denied if there are compelling reasons put forth. The question of compelling reasons, Your Honor, we have not gotten there. We will get there. In fact, in the case that we concluded, the Busit case, there is one of the accused person was actually out on bond. The matter was heard while the accused person was out on bond. I'm actually handling another matter in this court where an accused person has been on bond. So it is not true that there's a rule that they are denied bond, and that cannot stand as a reason why they will not take plea today. Your Honor, on the other issue, on this issue of the proviso under Section 2 of OTA, Mr. Kibe has talked about a message. What message are we sending? And it's important that we know to what end are we going to charge these people under OTA. Article 37, the message in Article 37 is that every individual, every Kenyan has a right to demonstrate. But there are conditions to that right. That it must be peaceful, among other reasons, including unarmed. But the message also in Section 2 is that in your exercising of your rights under Section 37 of the Constitution, as you demonstrate, you're not allowed to do several things. And if you do them, then those acts should be and shall be deemed as terrorist acts. And those acts, Your Honor, have been enumerated there that include serious damage to property, violence against a person, and acts that endangers the life of other people. Your Honor, the particulars of the offense of in Porter in the charge sheet that in the case that is before you include issues to do with serious damage, especially to government property. And it is on this strength that we submit to Your Honor that the actions of persons who took advantage of demonstrations, their actions, Your Honor, rightly falls under under a Terrorism Act and can be interpreted as so. And therefore, the charge sheet that is before you, Your Honor, we submit, it is not defective, and the accused persons should proceed and take plea. So those are the two messages that we are trying to achieve.
Just a few that I have been able to pick up. Is not here for the whole.
Kinds of offenses and violations is undermining the war on terrorism. I urge Your Honor to find that the matters that are stated in this charge sheet are well tried by another court, particularly a court in Matu, because that's a locality of the people before you. So that, Your Honor, my learned friend can get more time in the diary to listen to more serious terrorist-related matters. Like Dusit and Westgate. Like those. That's the level. For now, let us leave assault and people throwing stones to the local courts where these offenses take place. And Your Honor, I don't think I have anything else to add.
Your Honor, there's only one point that was made by the learned colleague.
Yes, sir. Just a
That
Just one point. My learned colleague is asserting that when confronted with the issue that charging people in this court with committing terrorist acts makes them criminals, makes them terrorists, his response is that because they are not charged with being members of a terrorist organization, that does not mean that they are terrorists. You cannot have your cake and eat it. We commonly say that. This is the classical situation. A terrorist, by the plain meaning of English, is a person who commits terrorist acts. So it's not possible for the prosecution to charge people with terrorist act and then say, no, we have not called protesters terrorists. That is what it means in plain English. Why is the prosecution so keen to make that distinction? It is for a simple reason, Your Honor, that the prosecution is aware that the conscience of this court, every patriotic Kenyan, every rational Kenyan would be offended to call political protesters terrorists. That is exactly what they have done. Your Honor, they should not be allowed to get away with it. By trying to do something, then to try and run away from it. You are most obliged, Your Honor.
Mr. Kongo, just one observation from what has been submitted by my learned seniors. Your Honor, it's only in this country where the so-called terrorists come out in large numbers when the youth of this republic are exercising their constitutional rights under Article 37. Your Honor, we've had other groups come out to demonstrate before in this country. Even us, the LSK, sometimes we come out and demonstrate. Your Honor, the doctors are always on strike. They are always on the road. Your Honor, even our learned senior, His Excellency, Mr. Kalonzo Musyoka,
I'm an expert.
is an expert in demonstration. And Raila Odinga, the list goes on. But in those instances, Your Honor, we never had this kind of charges where the demonstrators were brought to this specific court and charged with the offenses of terrorism. So, Your Honor, what I'm saying is that this goes out to show you the mischief that is behind these charges. And I pray that, Your Honor, this court should not entertain that kind of mischief that is politically motivated. Your Honor, there are other charges that the accused persons can be charged in other courts other than this. So, Your Honor, we pray that as you retire to write the ruling, you will look at what we've submitted and clearly see that there is some sort of malice on the part of the state. That's all, Your Honor.
Your Your Honor, we truly are honored as defense for your patience, continued patience. And we have no further submission. We now know, so it's clear. In fact, I must thank our friend, Mwita, was it? Kiragu Watuita, for making so clear, showing clearly what is before you. So we shall look forward to your ruling in this matter as we insist that the suspect should not take a plea on this matter of terrorism. I would wish you could, Your Honor, we had originally thought we could leave you to design on these issues, but we have an important suspect as well. All of our suspects are Kenyans, are important, but there is a member of parliament. I hope his file could be brought because we have chosen to wait until we represent him. Thank you.
You know, just a clarification as to the issues that were submitted by, what is it? Doita. Yes, Kiragu Doita. You know,
We are getting to know each other in this court, Your Honor. All these practicing advocates have now come together.
You know, the law states that whenever a new issue is raised that was not raised during the
Yes, Mr. Bashir, I grant you the right.
yes, we have the right to respond to what he has raised, and this is my submission.
That was with respect to
In respect to section 40A.
40A.
Yes, Your Honor. The council has submitted about the composition of NCTC before then delving into the particulars of the facts, and alluded to the fact that the NCTC, with its formidable composition, has delved into investigating minor assault cases.
Yeah, no, that was not my submission. My submission was that the matters terrorism are overseen, not investigated. They're overseen by a body where even the president sits, through the National Security Council.
Your Honor, defense, what you said is on the record. Yeah, and so there is no risk that it will be misinterpreted. I already have captured it.
And Your Honor, permission of counsel, because I don't want to aggress on his time.
Yes.
I was actually a member of the National Security Council.
Yes.
And it is true, this is a very important institution. We cannot allow ourselves to now bring the fight against terrorism to this level.
Thank you.
And the
Mr.
minister
Bashir,
here
you can
was.
proceed, and there is no risk that anything
no
that
risk.
you've said will be changed on the record.
So the reason the composition was given is to trivialize, to make it trivial the matters that are subject to this trial today. Your Honor, the said composition does not deal with investigation of terrorism cases, but deals with other issues including coordination, database, and analysis of information, among so many other things. And I know that if council would have gone down there, they would have known why NCTC is in existence in the fight against terrorism.
So you say it deals with?
Doesn't deal with active investigation.
Yes.
And therefore deals with databases, coordination of various stakeholders in NCTC, in National Counterterrorism Work, and they develop strategies and analysis of information among so many other functions. So the issues of investigation of terrorism are squarely with the Anti-Terrorism Police Unit, a unit mandated to conduct investigations of terrorism cases. In this case, the council just went to the specific counts on assault. went to one count of assault to the other count of assault that are charged alongside the count for terrorism, for commission of terrorist acts. It is therefore not true that these matters are trivial as suggested, and trivial matters are already listed as per the assault, Your Honor. Terrorism, and you know, it is important that they listen, because terrorism is not on the gravity of the offense that has been committed. You can be charged for terrorism, and I read, you know, when we began, action or threat of action. If there is a threat of action that is so formidable, and the threat does not crystallize to an action, it doesn't remove it from the scope of terrorism. And this is something that has to be understood by everyone in Kenya. The terrorism act is not on the bomb blast.
It's still limited himself.
Yes, to the NCTC. Yona, I am. And if I'm out of order, please, the court will tell me I'm out of order.
Can I therefore say that the response was limited to section 40A?
Yes. 40A, as long as he submitted and connected it with the offenses that he went through.
Now, can I also say,
yes,
that the issues that you have submitted very early on what constitute a terrorist act, and you are actually making reference to what you had said earlier, which is that it does not need to be an act, it also includes a threat.
Yes, Your Honor.
And all that is on the record. With respect to the response, I understood you to mean that the new area that had been brought out was the issue of the constitution of the NCTC,
yes,
and section 40A.
And also the issue of stones and the triviality of the attacks. He brought it right now. He brought the issue of that these people are being attacked in their fingers with stones, and this is not terrorism. That had not been raised.
So you're saying that it is your contention, therefore,
yes,
that the charges hearing are not trivial, as counsel would have the court believe.
Yes, Your Honor.
I believe that is already on the record, as I've stated it.
Very well, Your Honor.
Yeah.
And therefore, this issue, Your Honor, of trivializing the charge sheet as is based on the other charges that we have specifically listed them under the penal code should not be mixed up. We ask the court to appreciate count 1 on terrorism and the evidence that is there in the particulars as at that charge sheet, and also consider the other counts, count 2 all the way to count number 7, as matters that arose in the course of the same transaction. Thank you.
Look, my friend.
I believe that brings to the end the presentations from both sides, and I think that what now remains is for directions on the way forward.
And as you issue the directions in respect of this matter,
yes,
senior counsel had raised an issue about a file that is pending.
Yes.
If perhaps the DPP would be magnanimous enough to serve us with the pleadings that immediately you are done, then you can move on that file. The pleadings that you have their file based on that matter.
They'll be served, Your Honor.
Thank you very much. I think that response should suffice.
Your Honor, maybe on a lighter note,
yes,
there is a deep suspicion among us that the member of Parliament may also be a rural urban migrator, courtesy of these new charges. So maybe it would make sense if maybe the court can look at the file and see whether these submissions can be adopted in the same way.
Now, can I say this? Can I say this? I think there is we are treading on slippery ground, because that matter is not yet, the court is not yet vested with the issue in question. You may all be aware of it, but until it is brought to my attention, I cannot issue directions there. Yes. Good. Now, this is the direction that this court will grant, will give in regards to the 3 matters that we have been dealing with. Now, owing to the lengthy submissions that have been made before the court by counsel from both sides, and owing to the importance and gravity of the issues that have been raised, this court shall reserve the ruling in these 3 matters to the 10th of July. In the meantime, the accused persons and the suspects in the hearing will remain in custody, in police custody, in the respective police stations where they are currently being held. With respect to accused number 11, in criminal case number E069 of 2025, the order that he be held separately from adults will remain. So we come back for ruling in these 3 matters on the 10th of July at 9 a.m. Yes. Thank you very much. We will adjourn so that you can consider the other matter and we can come back. Thank you very much.